let's go on to Metcalf. So I think Metcalf's a very interesting case, and it's an example where a court did sort of apply this kind of concept that was, probably intended for a different kind of work entirely, but applied it to a distinctive, expressive work, right? Like in this case, it was I guess a treatment or a screenplay for a television program versus a successful television program. There were, first of all, there was very strong evidence of access, and that's one of the elements in the copyright infringement case when I asked you what the elements were, right? Very strong evidence of access in that case. And secondly, there were a whole series of points in the two works that were what the court said strikingly similar. There were like about 15 or 20 points that at a very detailed level, not at the level of an idea, oh, they both involve doctors, but at a more specific level than that the court found there was enough of those in enough of the same order that they were in the plaintiff's work that they refused to dismiss the case. As it turns out, the plaintiff was wrong, according to the jury, and there wasn't substantial similarity. And I'm actually a little surprised if it got to a jury, because as we'll get to if we talk about blurred lines, California has basically a messed up version of jury instructions for substantial similarity. I mean, last time I looked, they basically don't have any, and it's up to the lawyers in the case. They have it on every other element of copyright infringement, but not on substantial similarity.
That's true. There is no instruction. The former one, which has now been rejected, said that substantial similarity is similarity that is substantial.
I'm sure that helps jurors a lot. That said, the lawyers end up fighting over what the instructions are going to be. And one of those instructions derives from another kind of a cockamamie idea developed out of the Ninth Circuit, which is that if works are similar in total concept and feel, they might be substantially similar and infringing. And why do I say that's cockamamie? Well, Lucifer says it's cockamamie anyway, because concepts aren't protected by copyright. What is a feel? I don't know what a feel is. And so when it gets to a jury and the jury is given an instruction early on, like happened in the blurred lines case, that says, ideas aren't protectable by copyright, and then a few pages later and 10 instructions later, they're told, well, if you find the works to be similar in total concept and feel, well, then they're substantially similar. So a party that writes a song inspired by a feel of a classic soul song, without a lot of specific, really very little specific similarities, and I don't mean to blur on into the blurred lines case, but if they got in front of the jury and they said, well, yeah, it kind of has the same feel as a Marvin Gaye song, so substantial similarity. I'm guessing that that's what the jury did. And so I think that's, maybe we'll get a little more into total concept and feel as we go on, but as far as Feist goes, I just think it was a totally different case and didn't deal with the problem of what level of abstraction is too detailed to become more expression than an idea.